when you put bad banks together, they don't become a good bank. You put bad banks together, they still have the problem. So government now intervene by pumping money into that company for them to raise new capital. So that happened in CBG. So let's move on. Now,
Are you in support of this decision?
No, not at all.
To take 60% and
not
let it
at
go?
all. And that is where I'm not a lawyer, but I speak to lawyers a lot. And with my little common sense, I wanted to understand a few things. There is a procedural problem for me. When somebody is charged with a crime, he goes to court and he pleads guilty or not guilty. In this case, the 7, including Mr. Dufo, pleaded not guilty. If they pleaded not guilty, they have to now prove their case in court, and the judge will decide whether they are guilty or not.
That's right.
At what point did the AG start negotiating with them? If somebody has pleaded not guilty in court, where is there a negotiation? The other avenue for me is that when you plead...
Let me suggest that to you.
Okay.
So in our everyday practice, and I do this too many times, where I let my clients plead not guilty, even though you may think that they should be pleading guilty, but their first appearance, you let them plead not guilty. Then you begin to negotiate behind closed doors.
Okay.
Then if the negotiation works, you go back and change your plea.
Thank you.
And you can change it to a plea of guilty and then get a plea bargain and get away.
Thank you. So in that case, the only time you can now plead guilty, and then a plea bargaining comes in, and that plea bargain is presented to court as a way to ending the case. Did it happen in this case?
We are not aware of it.
It did not, because the man went to court. He's found no... Because bear in mind, the money retrieval is part of sentencing, because forfeiture is part of sentencing. When you are sentenced, your recovery of the money is part of sentencing. In another jurisdiction, you are given 5 years plus a forfeiture trial. So when you do not recover a certain amount that the court sets, you are now asked to come back and they will add to it. So let's say you are given 5 years and a forfeiture of, let's say, 60% or 80% of the money that you've gotten through ill-gotten gains. Then if you do not recover that money, at the end of your tenure, of your sentencing, you go back to court and the court says, yes, in failure to bring back the 80%, do another 4 years. So forfeiture, which is the recovery of the money, is part of sentencing. What we should remember, and I like what other people have said, that we are now creating an avenue for loot. Because when people realize that you can take enough, do anything that you want to do, and the NDC for me is sad because, bear in mind, they promise us that they are going to protect our public purse. In protecting the public purse, the Minister of Finance, and I like when you read that thing to Professor Abuchi, is that 2.2. They are saying that they don't want to continue because what? They don't want to now go, my brother has repeated it, chase after whatever. Somebody is doing 15 years today, right? How much was her crime? 15 years. So what the state is supposed to go after is the indictment, is the punishment. Forget the money, because a crime has been committed. And as my brother rightfully said, if you now plead not guilty, then prove your case. But if your lawyers negotiate and you want to refund, then there should be an indictment, because you can't have it both ways. You can't have a no indictment, because now, as we speak...
What they have done is to file a nolli prosequi, which is a power given to Attorney General or the state to, at any time within the trial, decide to stop it.
Yes, so that the person goes away with the money.
Yeah, you don't need any excuse. And Professor Bochi was trying to explain something. We have two of them. We have what we call withdrawal, and we have a nolli prosequi. When the withdrawal is filed after the prosecution have closed their case, there is an acquittal and discharge. The case cannot be revisited anymore. You understand?
Yes.
In this case, he's explaining to you that this is a nolli prosequi, and nolli prosequi does not amount to acquittal. It only amounts to a discharge. So they have said, financial prudence. We don't want to waste more
but
money.
It's not for them. You see, I like the bit where Professor Bochi comes in and says there's a discretion and the Constitution gives discretion and all that. But it's a state's money. I mean, I really don't think that somebody appointed an Attorney General today, 2.2. Attorney General is in court, is in many courts. And rightfully, all the lawyers have said that you give a nolli prosequi, you don't give explanation. Case ends there, because they've done it in several cases, right? there are many non-prosecutor that no explanation was given. Everybody will speculate and say whatever. But this case, you've opened yourself to the conversation.
It's progressive jurisprudence.
Well, that's fine. But
there's public interest. So if you file a non-prosecutor, explain.
But the point is that what explanation you are given that you think that you do not want to now chase after that because it is not well. Attorney General across the country, the state attorneys are in court for 100 cedis, 20 cedis, 50 cedis, people who have stolen goods. They are being prosecuted.
That's right.
So why are you telling me that 2.2 billion is what? Is you don't have enough money to go after 2.2 billion? That is where the state is looking. And especially from a government who told us that they are going to protect our public purse. I think I'll leave.